Okay, well, we've hit the magical hour and we are ready to commence our great program tonight. My name is Camille Wimbish. I'm with Ohio Voice, and I'm here today to do our Blueprint for Democracy series. We're going to be focusing on democracy in the courts, and we are joined by some really fantastic panelists. We've got some great folks here. I see lots of folks from Toledo and Columbus and Cleveland and Delaware. So it's really exciting to have so many people here to talk about our sentencing database and what we can do to help sort of crack away at some of those implicit biases that are sneaking through our justice system. So we are going to be having some remarks from our panelists, and then we're going to have questions, time for questions and answers. If folks want to pop questions in the chat as we get them, that will be fine. And we'll make sure that we get to those all in the question and answer session. Do we have slides ready to roll? Excellent. So we've got several great, wonderful co-hosts who've helped to put this program together. They are Common Cause Ohio, the ACLU of Ohio, the Freedom BLOC, and the Ohio Fair Courts Alliance. And again, I'm Camille Wimbish. I'm going to be helping to moderate the event. And let's go to the next slide. All right, so this is a Blueprint for Democracy. We are going to be doing 3 webinars focused on the courts and democracy. And the overall goal is really to educate Ohioans about some of the challenges and opportunities around our courts, and to start to build a fair courts agenda that addresses structural racism, money and judicial races, and ethical standards. Today is the first webinar in the series. We've got 2 more really fantastic ones coming up next month, and we'll give you all this information following our presentations. All right, so let's dive into tonight. We are going to be joined by Sara Andrews, who's the Executive Director of the Ohio Sentencing Commission. The Ohio Sentencing Commission is an affiliated office of the Supreme Court of Ohio that seeks to enhance justice and ensure fair sentencing. She previously served as the department on the Ohio Department of Rehabilitation and Correction for 20 years. Next up, we'll be joined by Justice Michael Donnelly. Justice Donnelly serves as a justice on the Supreme Court who took office in 2019. Prior to that, he served as a judge on the Cuyahoga County Court of Common Pleas for 14 years. Next up, we've got Judge Laurel Beatty Blunt. Judge Beatty Blunt was elected to her current position on the 10th District Court of Appeals in November of 2018. Prior to becoming an appellate judge, she served as a Franklin County Court of Common Pleas judge from 2009 to 2018. And then rounding out the bunch, we've got Gary Daniels. Gary is the chief lobbyist of the ACLU of Ohio. He works in the Columbus office and has also been a really valuable member for the ACLU for about 20 years. So welcome all. Next slide. So essentially, we're going to go through some remarks. Each panelist will get around 10 minutes to share information about the sentencing database and their perspectives. Then we're going to leave time for questions and answers and let folks know how they can get involved. Next slide. All right, so essentially, I'm super excited to bring this topic to you. I know for lots of us, this last year and a half has been really challenging between the pandemic, the racial uprisings. There's just lots of division and really sort of really divisive politics. And so it's really exciting to see that we have an opportunity to sort of advance a really bipartisan reform that's going to really start to take hold and look at ways we can make concrete improvements to really root out some of that racial bias and implicit bias in our court system. So I'm really excited to learn more about this database. And I know that Sara Andrews is going to run through some of the specifics about how the database works. Sara?
All right, thank you, Camille. And I guess that's code for she's going to be the boring part of this presentation.
Not at all.
But good evening. It's a pleasure to be with you. And as Camille mentioned, the Ohio Criminal Sentencing Commission is an affiliated office of the Supreme Court of Ohio. And the commission was created by statute in the early 90s in response to 4 concerns. And I think that you'll hear those 4 concerns echoed throughout the presentation tonight. And here we are many years later. So those 4 concerns were prison population and cost, overly complicated sentencing laws, racial disparity in sentencing, and lack of judicial discretion. We continue to work to meet those challenges, striving to enhance justice and ensure fair sentencing in Ohio. Our focus is not unlike other sentencing and criminal justice commissions across the country, and we're proud and actually quite fortunate to work and consult with them on a regular basis. For those of you who don't know, commissions are designed to tell the story behind the data. We illustrate deep intricacies of sentencing patterns and trends and try to weave them together to inform and engage others in development of sound public policy. This year is the 25th anniversary of the enactment of Senate Bill 2. And the reality is, and many of you have heard this 100 times before, is that we are suffering from the cumulative effect of tinkering with sentencing structure, unlimited data sources, and a crime-by-crime basis. And that leads me to that slide that says felony sentencing is exceedingly complex. So slide number 9, I think, in the deck. The next 2 slides number 10 and 11, really give you a display, and we've included the actual document in your materials, but we took a look at just one sentencing statute, the sentencing statute 2919, and thought, well, how can we break it down into simple terms of how it's evolved? And if you look at the slide, you'll see that in 1996, in simplest terms, if we count the number of times the word if is used, the number of subsections, and the word count, you'll see that in 1996, the number of times the word if used was 16, whereas in 2021, we're up to 39 times. And in 1996, the number of subsections just in that one sentencing hearing section was 19, and today we're at 46. The word count in 1996 was 1,242, and today it's 3,176. And so what that tells us is that not only is sentencing exceedingly complex, but available sentencing data focuses on few outcomes. And really, it focuses on people sentenced to prison. What data is available doesn't tell us about punishments other than prison or about the process of sentencing, like the factors that influence the sentence. You'll hear me say more than once today that it has been said the destination is important, but to understand the true dynamics of sentencing, so is the road. And so the next slide. Sentencing data provides opportunity for powerful research, including the ability to parse comparative information between counties and recognize that community standards can drive law enforcement, prosecution, and sentencing decision-making. Next slide. But please know that it is more than the data. We are committed to helping judges and others navigate this exceedingly complex sentencing structure. And I'm going to give you a little background that may or may not bore you. So for, if you need to take a break, now would be the time. But in September 2019, Chief Justice O'Connor asked us to convene a uniform sentencing entry ad hoc committee. And the mission of that committee was to develop a model uniform sentencing entry that would prescribe the most clear and concise minimum language required to comply with Criminal Rule 32 and existing case law. As we approached that effort, we understood that we needed to leverage technology, and we wanted to create what we call a living document that would reflect changes in statute and case law. Because as I said, we're suffering from this cumulative effect. So things are changing all the time. We keep piling on to current statutes. So we needed a way to capture the real-time sentencing related information. And so we thought that an academic partnership made sense, especially since in Ohio, we're resource rich in that regard. And so in early 2020, pre-COVID, we met with a number of universities to talk about the uniform sentencing entry, our vision, and how best to accomplish it in a way that would be efficient, reduce duplication, and not fiscally burden courts or local government. As a result, as you all know, we contracted with the University of Cincinnati School of Information Technology Solutions Center. And by August 2020, shy of 1 year of work on the ad hoc committee, in collaboration with various associations and interested parties, the committee proposed a package of documents for felony sentencing that included that uniform sentencing entry, method of conviction entries, and good civics forms. Next slide. We knew that that package of felony sentencing documents was the first step to establish standardized, common data essential for identifying relationships and trends common to all felony courts in Ohio. And by September of last year, the Ohio Sentencing Data Platform was created to help judges implement that uniform sentencing entry and method of conviction entries. And this will, for the first time, generate a standardized statewide felony sentencing entry template that ensures clear, comprehensible sentences and promotes confidence in the system. Next slide. We think that it will empower courts with accessible and reliable information. The Ohio Sentencing Data Platform will achieve goals that include using data to inform decision-making. It will improve transparency, make data accessible for the public, practitioners, and research. And what's important to understand is that available and searchable data transcends any one branch of government, because it's the only objective way to make sure what we're doing works and is or isn't achieving the intended results. Next slide. We committed ourselves to foundational ground rules, such as integrating the templates with existing court processes, utilizing an incremental and slow-paced process, and developing an inclusive and comprehensive governance structure. Next slide. As you can see, the governance structure for the project is diverse, it's complex, and it includes a wide range of participants. In fact, as you may know, and as demonstrated by those on this panel this evening, the effort to implement the uniform sentencing entries and create that sentencing data platform has been promoted by judges and practitioners. We've resisted the traditional approach of state government, you know, the one that mandates something and then just expects everybody's going to do it. Instead, our strategy has been deliberate. It's been what we call iterative, and it demonstrates the value of the uniform sentencing entry for judges and court staff, while at the same time giving us a way to capture standardized statewide information about sentencing. The governance structure continues to evolve, and it will always guide the project. We are clearly in the early stages of movement toward this data-informed environment, and that will allow for comprehensive understanding and analysis of felony sentencing and someday the criminal justice system. Next slide. We realize and recognize and appreciate that sentences are a journey. It's not a singular point in time. Next slide. Sentencing is a story, it's not just a number. If you think about the difference in these two scenarios, when someone says County X sent 250 people to prison on drug offenses, this presents sentencing as a number. It's 250 drug offenses. But what we really want to know is that have information that tells us that County X sent those 250 people who may have had a prior felony offense on drug trafficking charges, and the amounts of the drug trafficking charges were 5 times the bulk while carrying a weapon into a prison. I mean, we really need all the elements of an offense and a sentence to tell the story. And telling the story of sentencing is critical, and I think the judges on the panel will agree that that has helped inspire the engagement of courts and judges, that getting past just a number is important. Next slide. You'll see that We have a website, the Ohio Sentencing Data Platform website, which has a current map, and I think it's going to be in your chat materials. But you'll see that joining the project is a process that begins with an informational meeting and then a site or a learning visit, which is followed by piloting or testing the system. And as of October 29th, 2021, learning visits with 44 common pleas judges, or 18% of them in 16 counties, have been conducted. And again, for the current map, because we update it every week or as needed, so please check the website. Next slide. Where do we go from here? So as I mentioned earlier, the destination is important, but to understand the true dynamics of sentencing, so is the road. Our work is principled on that iterative approach that I mentioned, which allows us to learn as we go, adjust when necessary, and keep our promise of the foundational ground rules that I mentioned before. We are committed to phases over time, and while all of us want information now and are accustomed to pulling up Google for everything, we must be disciplined in this project and take time to get it right. Lines of effort are defined and shared. Next slide. And this is kind of a messy slide, but it's our roadmap. It reflects the work ahead and the project vision. The project vision is to tell the story of the administration of justice in criminal sentencing in the state of Ohio, and to support continuous improvement and to increase public confidence in the criminal justice system. And the mission is to develop a platform that seamlessly integrates the Uniform Sentencing Entry Package into existing court practices, provides judges with the most up-to-date entry language, information, and the ability to tell the story of their sentences. And while at the same time, that information captures data that will better inform not only the judges, but stakeholders, the public, on criminal justice practices statewide. I mean, if you think about it, our initial development or discovery phase there on the left-hand side, those three smaller boxes that are probably impossible to read, that discovery phase of the sentencing data platform began in October of 2020 with Judge Reed, one pilot site, one court in Allen County. And we've since expanded to 16 counties and 44 judges that are in some way participating in the project. The response has frankly exceeded our expectations. Next slide. In closing, we're optimistic that we are on the verge of significant, meaningful long-term change and turning the tide on decades-long missed opportunities to better understand how felony sentencing works in Ohio. With that, it's now my pleasure to turn things over to Justice Donnelly, who has certainly has been, and is a champion of this work, and he'll tell you why. Thank you,
Sarah. It's great to be here. Thank you for the invitation. I'm very honored to be on this panel with my distinguished co-presenters. Before we get into my PowerPoint, is a few preliminary remarks. Whenever you advocate for reform, as I've found in the past, I've always encountered some level of resistance from my former colleagues. And by simply using the word reform, some of them recoil defensively as if it's a blanket criticism of the many great women and men, judges, prosecutors, defense lawyers who are doing great work every single day in our justice system to bring justice to the people of Ohio. But what I like to point out is every single reform or advancement that I've seen take place over the course of my career, starting with open discovery of records between prosecutors and defense lawyers, drug courts, mental health courts. It's important to remember that those were initially resisted, and now they're universally praised. I have come from studying this issue to believe this is the most important criminal justice undertaking we can take as a state of Ohio, and it will take our ability to treat more people more fairly and equally within the system in sentencing light years from where we are right now. So the policies that underlie any sentencing laws in any state, it's complex. Number one, the maintenance of law and order in society. If you have laws that are expected to be followed, there has to be consequences when those laws are broken. Public safety, protecting people from violent individuals who would be prone to hurt people. Rehabilitating offenders and allowing them to, at one point, re-enter society when they're no longer considered a threat. However, public confidence in the system is diminished when citizens believe that the outcomes of sentencing are not so much governed by the rule of law, which requires fairness and proportionality to the conduct involved, but are more governed by the particular proclivity of the sentencing judge that they are assigned to at their initial arraignment room, randomly, but not inconsequentially. So, you know, when I advocate for reform, I always think a great starting point is, and we can advance the slide, let's start with what the status quo is. And I'm going to give you my description of the status quo, and any lawyers or judges that might be on here that want to disagree, now's the time to do it. Because if you can get an assessment as to what are the status quo, you can advance frame, please. You can make the desk, should we stay the course, how we're doing, or I'm in this camp, should we change the system? So if you could advance the screen, I'm going to show you, before Senate Bill 2, our current sentencing laws were implemented back in 1996. These were the ranges that existed before then. It was a totally different design of system. It was a system in which power governing criminal conduct and sentences was shared by the three co-equal branches of government. The legislature set the ranges. There were, for violent crimes, there were mostly indefinite ranges. The judges imposed those sentences. They had discretion. They could exercise probation. As you could see, they could sentence someone, let's say an aggravated felony, that would be a rape charge. You could sentence 5, 6, 7, 8, 9, 10 to 25 years. And then the person would enter the prison system. Power was shared over those offenders with the executive branch, the prison branch. And it makes sense because not all prisoners act the same. Some rehabilitate themselves, some do not. But when Senate Bill 2 was implemented in 1996, the design completely changed. Next frame, please. Okay, so Senate Bill 2, when I was a prosecutor and up in the time till the time I took the bench in 2005, these are the laws I sentenced people to. They got rid of indefinite sentences. This was supposed to be called truth in sentencing. People thought they were getting lied to because people were getting let out earlier than they were told on the nightly news. Someone got 5 to 25 and they found out that they actually got out in 3 years because there were incentives for prisoners who engaged in the acts of rehabilitation and demonstrated good conduct. They could reduce their sentences. And that makes sense because human nature is motivated by incentives. They got rid of this. It doesn't matter how bad a prisoner acts or how good a prisoner acts. If they got 10 years, unless that judge gave them judicial release, they were going to do every single day of that. And that bad prisoner and that good prisoner were getting out on the same day. They're being given a parole officer's name who would supervise them as they re-entered society. They got rid of an active parole board that could, make those decisions much earlier, that this person doesn't need to be here any longer. So here we go into the truth in sentencing. Back in 2011, they extended the range there. And then the next frame will show there's been a movement ever since the Reagan-Tokes tragedy that you could see an extension back into indefinite sentences because the legislature, after that tragedy occurred, they said that this makes no sense. How can we just let someone who has demonstrated throughout their prison career that they are still a violent individual just because they've finished their flat time, that they should be re-entered society? So this is the result of that change. So next frame, please. Okay, back when in 1996, our legislature knew that in order to keep consistent and to treat people with similarly situated offenders with similar sentences, that you needed to collect data about every single offender. Okay, because that's the only way you can do it, is to know, collectively how judges are sentencing. The problem is we never did it. We never did it in any centralized fashion. In the 88 counties, they did it, but it's not accessible in any easily accessible way. So next frame, please. So this is the legislative history that directed the courts to collect the name of the judge, the race, the ethnic background, the gender, the religion of the defendant. Okay, so next frame. Some frames, I think some frame may have gotten taken out. There was a frame that I wanted to talk to you about, 29, 29, 11, and 12. Okay, this is the cornerstone of our sentencing laws. For those of you unfamiliar what judges do when they sentence, this was considered the cornerstone of Senate Bill 2. I had it for 14 years laminated and it sat on my trial bench every day. And what it says is, after you listen to the advocates, the judges are supposed to formulate a sentence that adequately punishes the offender, protects the community from future offenses that the offender might commit, set the offender on a course towards rehabilitation. And it said, using the least amount of our limited public resources. This was supposed to be a limiting function on the judges to remember every sentence you have carries with it a monetary amount that is expended in order to incarcerate that person. We don't want, we want crimes commensurate with the conduct involved. And so that proportionality was built into that command in 29, 29, 11. And it also said, you are to treat similarly situated offenders with similar sentences, regardless of irrelevant factors like the color of their skin or their place in society. Now, I knew that it said that for 14 years, but I didn't think much about that because I just thought, well, I'll try the best I can. The new judges that are taking the bench, interestingly, who are familiarizing themselves with sentencing law, they're asking questions of old judges like me. Hey, how do you do that? How do you do that if you don't know what other judges are sentencing to? And the only thing you can do is say, well, just try your best, because there's no data. Now, the check on the system, when they implemented Senate Bill 2, the sentencing laws that I operated under, it was intended by the legislature that the Court of Appeals would have the ability to have a check. We have a system of checks and balances, very important, so that, sentences that aren't based on the evidence or are way excessive, that they would be able to correct a sentence that wasn't supported by the record. Well, a series of cases have taken place over both U.S. Supreme Court and Ohio Supreme Court cases have taken place over the course of time that have completely extinguished the Court of Appeals' ability, as long as it's within the legislative range and the trial court says what I've referred to in some of my dissents as magic words or talismanic words, as long as they say that they considered 29, 29, 11, and 12, or if they have multiple counts in front of them and they want to give the offender consecutive sentences and the offender has a history of criminal conduct, all that judge has to say is the offender's history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime. And as a result of these court decisions, as long as they say that and nothing else about the reasoning of their sentencing, they are completely insulated from any type of meaningful appellate review. Next slides, please. Sara mentioned in her program about the over-criminalization that has taken place since the 80s. On the left is the criminal code as it existed in the 80s. On the right is the criminal code as it exists now, with all the criminal new crimes, gun specifications, mandatory sentencing, registration requirements that have taken over since that time. And just so you're aware about prison population, in the 70s, the prison population was around 10,000. It's now up around 50,000 men and women. Next slide, please. We have known since 2008, when the National Center of State Courts did a study of 23 states about what we call guardrails, things that rein in judicial discretion, that keeps sentences consistent and proportional to the conduct. Since meaningful appellate review is essentially dead in the state of Ohio, this report basically indicates that Ohio ranked dead last with Wisconsin in having no guardrails on judicial discretion. So when you have no checks on trial courts checks, what do you get? You get sentences that are for violent and nonviolent sentences that are literally all over the board. Next slide, please. Okay, so here's a case where these next two frames are going to show you the vast power that trial court judges have. Again, unchecked power. Here's a defendant who was convicted of sexually molesting an 11-year-old boy. He received a 6-month sentence. Next slide. This is the first case I reviewed as an Ohio Supreme Court judge. This woman is named Susan Gwen. She was a 55-year-old woman who had no record to speak of. She was going in and out of nursing homes in her area for a number of years, stealing trinkets, personal items, some of which had strong sentimental value for the people she was stealing from. She was hoarding them in her house. She wasn't reselling them as traditional thieves like to do with expensive items, which indicated to me as a former mental health court judge, there probably was a mental health issue taking place. It was going over a number of years. She got indicted on numerous 35 counts of high-level felonies. She received a lawyer. They negotiated a plea agreement. At her plea hearing, the judge went over the vast amount of things that could possibly happen to her if she entered the plea agreement. So, and this included years and years in prison, but he also indicated, I can give you the ability of probation. So he said, if I give you prison. The prosecutor said nothing about what they intended to advocate for sentencing. So Susan, with the advice of her attorney, entered a plea. So 30 days later, she shows up at her sentencing hearing. And for the first time, she hears what the state plans on advocating for. They stand up in court and they ask for 42 years. The defense lawyer gets up and says, I'm asking for probation. And the judge imposed a 65-year sentence over what the prosecutor asked for. So Susan Gwen showed up at her sentencing hearing, not knowing she was going to probation, going home for probation, or whether she would die in prison. She found out the latter because she has to live to 120, and she has no chance. There's no parole board that's ever going to review it. That doesn't exist under the law. So she's going to die in prison, and that sentence was ultimately upheld. So this shows you the vast power that exists on any given case, given the amount of counts that might be before a trial court judge. Next case. Here's a case that ran in Cleveland, and I consider it one of the most important stories about the Ohio sentencing laws to ever been published. And it was no deep dive into the data of Cuyahoga County. It just happened to be reported by a reporter who was in the right place in the right time and covered two different sentencing hearings that seemed like they involved two similar crimes. The woman on the left from Pepper Pike, allegedly someone from privilege, and was able to afford a top-notch attorney. She was convicted of stealing $250,000 from her city where she worked. She received the probation. The woman on the right, the Black woman, Carla Hopkins, she was convicted of stealing $42,000. The one on the left was able to, fortunately for the city, make restitution, full restitution after she caught. The one on the right was not. These were the main differences from the case. The one on the left received probation, and the one on the right received 18 months in prison at their sentencing. And the reporter said, I gotta ask this question, why the different outcomes? So I agreed to participate in the story because I wanted to underscore that it was not the fault of the individual judges involved. It's our sentencing laws and the lack of data that exists and the way they've written. The judges have no idea what the other judges are doing in terms of similar sentences. And so as a result, our current laws are designed to produce this kind of disparity, both racial and other forms of disparity every single day. And this reporter just happened to catch it. Next slide, please.
Justice Donnelly, can we save a few minutes for Judge Beatty Blunt?
Yes.
Come back to you if time permits.
Yeah. Am I over my time?
Yes.
Okay. Can I just end with
go ahead.
Last one. People always ask me, what's the argument against it collecting data? Next frame, please. Here, when that story ran, here's what a criminal defense attorney posted on his social media. And he said that he knows it's an imperfect system. Sometimes you get a severe sentence, or sometimes you get a light sentence, or sometimes you get most of the time you get someone in the middle. What they're proposing with the database, the cure is worse than the disease. But here's the most important line. And I appreciate the family of friends of Ms. Hopkins don't see it that way. She was the Black defendant who received a year. And that's what it comes down to. People are fine with an imperfect system, an unfair that produces disparate outcomes, unless it happens to them or someone they know. And I'll pass it over to my colleague, Judge Blunt. Thank you.
Judge Beatty Blunt, did you want to make some remarks, some comments?
Sure. You know, I wholeheartedly agree with Justice Donnelly, and I just wanted to share a couple comments with you all. Note that when he was talking about that Bosworth and Hopkins cases, note that he said it just happened to be a reporter who was in the right place at the right time. And that shows you how unavailable this information is. And so one criticism, and Justice Donnelly, please pipe in if you want to contribute to what I'm saying here, is, you know, judges are scared to be criticized in the media. But I take issue with that because we are elected officials. We are accountable to the public, and we cannot be afraid of that.
Oh, it looks like we may have lost Judge Beatty Blunt, or at least her connection appears to be unstable. How about we go to Gary Daniels, and we'll check back in with Judge Blunt after Gary.
Yes, thank you, Camille. And if I would have gambled on somebody's internet connection going bad, I would have easily placed money on myself. So it's not that I'm out of the woods at this point. So thank you, everybody. As was said earlier, I'm Gary Daniels, Chief Lobbyist for the ACLU of Ohio, where I have at this point worked about 23 years. Since 1995, there was a few years in between I didn't work, then I came back. So here I am again, and I've been lobbying the state legislature for about 13 years or so at this point, full time. And so a lot of my remarks are going to be framed and centered around doing comprehensive criminal justice and mass incarceration policy at the statewide level, and in particular with the state legislature. And thank you to Ohio Fair Courts Alliance and Common Cause Ohio and the Freedom BLOC for putting this this event on. So yeah, as I mentioned, I've been doing this work a long time, and there's always been a lot of talk about the need for a sentencing database and how bad it is that we make so many decisions without proper information. And at this point, I had just assumed, since I had heard this for so long, that it was just never going to happen because it had been talked about for so long with no visible progress. So we at the ACLU of Ohio are very excited that the sentencing database is coming out, is coming about through the leadership of such people as Chief Justice O'Connor, Justice Donnelly, Justice Beatty, Sara Andrews, and the whole Ohio Sentencing Commission and everybody else involved with this. You know, it's quite sort of almost alarming to sit through hearings on such things as the gambling bills and hear them talk about people can bet pitch per pitch in a baseball game or play by play on a football game, or sit through hearings on a recent data collection privacy bill and talk about all of the data that's out there about us and all of the ways that private companies take it and crunch it and resell it and configure it for other people who then crunch it and what have you. And then look at the criminal justice world here in Ohio and us not having anywhere close to that. So again, this is a very exciting development. And more specifically, when you look at something in Ohio where you look at the DRC, the prison systems website, and they put up there every year, they put commitment reports, who's going to prison for what reasons. And for the past 7 years, the #1 reason a person lands in an Ohio prison is because of drug possession. And that's the #1 reason the war on drugs rages mightily here in Ohio and in our legislature. But what we don't know about that, without a lot of impractical and expensive and time-consuming digging, is, you know, what counties are most responsible for sending people to prison for something like drug possession? What do the courts and judges do with people that violate their probation or post-release control, those conditions that are placed on them? What do judges do when they have discretion with regard to sentencing somebody to prison or not sentencing them, or for how long, for instance, if they have a sentencing range? What counties are plea deals accepted more often, perhaps, than other counties? These are all facts that are buried somewhere, inaccessible or practically inaccessible to almost all of us here in Ohio. And that's very frustrating when you do this at a statewide and sort of a 30,000-foot level, because oftentimes you're left wondering, what level of reform do we need here? Do we need a sledgehammer? It's not working, scrap it, start over. Or do we need a scalpel? The problem perhaps isn't statewide, but perhaps it lies with certain counties, certain courts, and certain judges. These are the things, again, would be very helpful to legislators and advocates and everybody involved in the system. Now, as much as we're looking forward to the sentencing database, we do have two, I would classify them as pretty major concerns at this point that maybe will be discussed more in the Q&A part of this, and I won't take long doing this. #1 is it's my understanding that as much as this data is going to drill down to, is going to be, for instance, you or somebody somewhere will be able to see counties of similar size. So for instance, you'll be able to see the data. I think the first breakdown is counties over 1 million people, which would be Cuyahoga, Hamilton, and Franklin County. So it doesn't drill down to the individual county. It doesn't drill down to the individual court, and it doesn't drill down to the individual judge if there is more than one judge on that county common pleas court or that appellate court or what have you. So again, we're left wondering, should the reform, should the efforts that we take, the advocates around Ohio, is it a sledgehammer or is it a scalpel? The other concern we have is what is currently being proposed or will soon be proposed with regard to the rules of superintendents and how these records are handled. Now, the rules of superintendents, for those of you who don't do this or get immersed in this on a daily basis, rules of superintendents are essentially the rules that govern the way that courts operate in Ohio. And this includes the records of the court. So if you've ever filed a public records request, a city council or a local school or what have you, you use the Ohio Revised Code. For the courts, they use the rules of superintendence. So currently with the rules of superintendence, what is being looked at, and apparently will at some point be before the Supreme Court justices, Ohio Supreme Court justices, for approval, perhaps, is language. Now, what they do is it would change the definition of case document and administrative document so that they essentially wouldn't be public or would only be public under certain situations. And the exact language reads, and I'm sorry I don't have this on a slide, the exact language reads, the data shall be available at the originating source, which I assume is the courts, if not otherwise exempt from public access. Now, the problem with that is it's incredibly hard to get useful data from even like one court sometimes, let alone 88 courts. And of course, it's not going to be the level of data that will be getting siphoned into the Ohio Criminal Sentencing Commission as a result of this database and the portal and everything else. And you may even have problems, as the ACLU of Ohio does from time to time, with courts that don't respond to records requests. The other language is, at the discretion of the Ohio Criminal Sentencing Commission, the commission may make data available to the public via a portal or the platform. Now, I don't know what exactly this means, but it sounds like, number one, the data will only be available via the platform, and that it is completely within the discretion of the Criminal Sentencing Commission what they release and what they do not. Now, I'm less concerned right now because I know that Sara Andrews and the Criminal Sentencing Commission have been a champion for this information and the sentencing database for a long, long time. But we don't know what further permutations of the Criminal Sentencing Commission there might be as the years or the decades go on. When I read this language, it looks like if the Criminal Sentencing Commission doesn't want to release any data, they do not have to. And exactly how that data would be released. So for researchers and for advocates and for and people like that, what exactly will we have access to? I envision, but again, do not know, that, for instance, the Criminal Sentencing Commission will say, we want to get as much information as possible out there to people to make it helpful for everybody involved. But, you know, there's only so many people at the Criminal Sentencing Commission and their budget is only so big. I am sure there will be a lot of data left on the table that perhaps not everybody in Ohio wants to look at, but that will still be very useful and people will not have access to, is the fear. Finally, the sentencing database, as positive as it can be and hopefully will be, it should be treated as the floor with regard to these efforts, because data is just data. Records are just records. If the courts don't do anything with this, if the judges don't change their behavior, even with the data we show them and say, look, you're very much an outlier with regard to this particular offense, this particular type of defendant, or what have you, that's going to be a problem if all we have is the data, but nothing really changes or little changes, practically speaking, on the ground. And again, if we don't know what the individual courts or the individual judges or the individual counties are doing, it will make it that much more difficult. So those are just some of the, or two big concerns with regard to this. We hope this works out. Even a sentencing database that only judges have access to can be very helpful, but we want as much access for as many people as possible because we feel that is the best way to evaluate what judges are doing and how the criminal justice system is operating.
Thank you so much. Now let's check back in. Judge Beatty Blunt, are you available? Can you hear us?
So sorry, everyone. The internet apparently just completely went out at my house. And so now I'm calling back in from my phone. One thing I want to point out to you all is that, so I was on the Common Pleas Court General Division for almost just shy of 10 years. So in that position, I did felony sentencing. And I also did many civil cases where the amount in dispute was over $15,000. And here's what you have to recognize about being a judge. sometimes there are no answers. Sometimes it's a case of first impression or something. There's no law to guide you. And sometimes both sides have valid points. As judges, sometimes we don't like the law, but we still have to apply it. And sometimes, especially with criminal justice, we have to do things that we don't want to do. For example, in one that I can think of are cases where there's mandatory sentencing based on the amount of drugs that someone possessed. And I saw lots of cases where the person had no prior criminal record at all, but under the law, I had to send them to prison. Based on what they had. A lot of times it was just like someone who the cartel had hired to just drive some drugs somewhere and they got caught. And so without a criminal record, a lot of times you would have put that person on probation, but for the fact that you had to send them to prison because of what the law said. And so it takes a tremendous amount of courage to be a judge. You have to just rely on what will help you sleep at night. And I noticed that a lot of the opposition to the sentencing database, in my opinion, stems from fear. It stems from fear of the media. It stems from fear of politics. Because don't forget, all judges in Ohio, from municipal court all the way up to the Supreme Court of Ohio, are elected. And so what you hear a lot of are the media is going to crucify me, or they're going to question me, or it's going to come back up in my campaign. That is not what this job is about. This job, you are there to decide something that no one else could decide for themselves. So you have to have the courage to get the job done. And then just our job is not one that should be influenced either by other people or by our fear of other people. I was very frightened there is an article out there that is in opposition to the sentencing database. And it talks about how judges want to uphold local norms. When I read that, not as a judge, but as a Black woman, it scared me to no words, because to me, in my mind, especially knowing the history of America, is that, we've had laws on the books for a long time, but they were not applied equally to all people. I mean, when you start talking about that, with the Constitution, because that really only applied to white male landowners. So we have to be so careful about why we want this information and why we might be scared of it. Because in my opinion, we really shouldn't be. As someone who used to do sentencing, I welcomed any opportunity to basically explain myself. I remember a case where there was a Somali Muslim woman that hit someone who was pushing a stroller, and the baby died. I got so many calls to my office that my secretary had become fearful, because so many of the calls started with, "Oh, but a baby died." But they ended with, "She should go back to where she came from." Thankfully for me, I was a sentencing judge that was not afraid. And in my mind, there's bad American Christian drivers. But I explained myself on the record, but if you weren't in my courtroom that day, you don't know that. The media didn't know that. Researchers who might be doing any type of research on felonies, they didn't know that. But when you look at the uniform sentencing entry, there are so many opportunities for judges to explain how they're coming to their decisions. And so I think that they should be looking at this as an opportunity, not as something that's going to be like a gotcha, because the gotcha opportunities are already out there. And so let's give the people who are interested in these cases the information that they need in order to do research, in order to do to report accurately. Also, let's talk about how the legislature can use this information, because I was also keenly aware, and Justice Donnelly and I have talked about this, I was keenly aware that as a judge in Columbus, I had so many more options than a judge in a rural county. I had so many options beyond sending someone to prison or to jail. And so, particularly with the heroin epidemic, even the legislature changed from let's not punish, let's treat these people. But this information would give them the information that they need to show where to put the treatment centers. Also, if you're a person that cares about how your taxpayer dollars are used, I understand there could be additional expenditures in order to get the information into the database, but I would rather spend my taxpayer dollars on that, on a good database that gives us the information that we need, than to spend that money on people who are sending nonviolent drug offenders to prison for a year with 9 months of jail time credit, which means that we are spending our taxpayer dollars for ODRC to shuffle people back and forth to prison just for 3 months. That money could, and also I've always found it ironic with ODRC, the longer that you are in prison, that's when you start getting the programming. So for example, in my example of the low-level drug offender that's there for 90 days, they're just there. We're just paying for them. They are not getting any type of treatment. And I think that that is relevant because if we're looking at our taxpayer dollars, let's look at what happens when people leave prison. And let's set them up not to go back. And so we need to allocate our resources appropriately in order to do that. And that does not include sending people to prison that don't need to be there. And if you have this database, you have information at your fingertips to show you that. Oftentimes as judges, we tend not to think of the financial ramifications of what we're doing because we just sentence and we're done. So that's another thing. Lastly, I think that this information would be fantastic for voters. And I don't really care if you're a lock them up and throw away the key, tough on crime voter, or if you are a defund the police voter. This information is going to give you information on who you might like to vote for, how you want your justice system that's run with your taxpayer dollars to go, and what we want to do with people who have been convicted of a crime. So that's why I support the sentencing database, and just say ditto to everything that Justice Donnelly said, hoping that if any of my cases go up there, he'll affirm me.
Thank you so much for all of our great panelists. I really enjoyed all of those remarks. And I see that we're joined by a number of other judges, Justice Pfeiffer, Judge Jameson, Judge Adrian, Judge Skinner. Maybe there's some other ones that a second that I didn't see, but thank you all for coming. Thank you for this really important conversation. Now's the time to hear from you guys. Catherine, do you have some questions queued up for us?
So we received a few questions in advance, and then we have some that are from the chat. So this is for Sara Andrews. The question that I had really had to do with, you said that there were a few counties that decided that they wanted to participate, and that there are some judges that chose to participate. What was it that moved these folks to choose to be part of the sentencing database?
I'm not sure. I think because thus far, all of the 44 judges that we've worked with and the 16 counties have all been volunteers. So I think they maybe speak a little bit of Judge Beatty Blunt's language of why not? It's time to do this. Of Justice Donnelly's points of I want to have better information. We've heard from the judges who are participating. Some of them feel like having that uniform sentencing entry and knowing everything that they need to know to impose that lawful sentence is critical and helpful. And then beyond that, then being able to really think about the sentences they're imposing. One judge in particular said, it's making me a better judge. And so I think it's a combination of factors, but thus far it's really been a willingness and engagement from the bench.
Well, just to stop.
Hey, Sarah, can I add something to that?
Oh,
I
please.
also think that a lot of judges have been very surprised. It was almost like the fact that this information didn't exist hadn't occurred to them. And so a lot of them are like, oh, wow, this doesn't exist. Let's make it happen. And so some of your volunteers are those people, aren't they, Sarah?
Yeah, we do have a lot of, I would say, judges who are interested in participating that don't have a long tenure in their role as a judge.
And then don't you have a couple who are participating who are skeptical?
We do. And in fact, we've asked those folks to participate and they've been very helpful. And I think now are helping now having understanding what we're doing and trying to see it from another side. Those skeptics have become less naysayers and more, okay, I see the value and I think there's real opportunity here. Just like you said, that word opportunity is important.
Mm-hmm.
Well, I have to say, I appreciate learning a little bit about why the judges are wanting to participate. I think it gives us a sense of how we can encourage this process to come together. Now, I used to run the Money in Politics project for many, many years. And one of the things very clear to me is you can't study away a problem. And so one of the things that I wondered about had to do with, I know that there are other states, and I'm going to throw this to you, Justice Donnelly, there are other states that have done these kind of sentencing databases. And I wondered about kind of the real world impact in other states and what kind of path there can be for the state of Ohio.
Well, I think there's a great path because the idea of promoting more fairness in the criminal justice system appeals to all different types of people along the political spectrum. Conservatives who are very concerned about fiscal responsibility, and progressives who are concerned about the human impact that mass incarceration has taken place. So we're at a unique period in time in our history where we can get both sides at the table because they both want to see this get done. And if you want to see evidence of that, I would encourage those in attendance to Google Florida's broken sentencing program laws, Florida's broken sentencing laws, because in 2016, some journalists did an investigative piece down there, and they did a deep dive into the sentencing practices of judges, and they found some very disturbing results. People of color were receiving exponentially more severe sentences than white defendants, even though on paper they looked exactly the same. Well, this created an outcry, and the legislature, the Republican-controlled legislature, responded. Especially the Speaker of the House down there, and they passed one of the biggest omnibus data-driven bills that would, if it is successful, will make Florida the most transparent state in terms of its criminal justice system. We have the opportunity to join Florida and states like New Jersey and become a leader. This is a movement that is going across the country. There's an organization called Measures for Justice that you can Google, and that's their sole mission, to get states to collect this data because they know it will lead to so many reforms and our ability to treat people and more fairly and get rid of systemic inequality, implicit and explicit bias in our system.
So one of the things that Gary asked about as he was giving his presentation was he said, what will we have access to? And so I wanted to turn this into what should we all have access to? I'm gonna throw this to each of you to say, well, what should be in this database? What will help both Ohioans, judges, folks that are worried about taxpayer money? What are the kinds of things that should be in this database? Oh, and Justice Donnelly, you're on mute.
Obviously, obvious ones like race of the defendant, prior criminal history. You have to have enough data so that people who want to draw conclusions make sure that you can make sure that they're comparing apples to apples and not apples to oranges. But there's one data point that I don't think has been included yet that I've been advocating for. If we were to include this in the data collection process, we would be the only state to do this, and we would be a leader. And that is to collect plea offers made by the prosecution. They should be on the record so that they can keep consistent with theirs. And if they're treating people different, they can explain why, and they better have legitimate reasons to do so. I mean, you're talking to a judge for a decade. I didn't meet with the parties off the record back in chambers. I didn't do that. I didn't talk about plea agreements on the record. We talked, and I saw in the chat someone said, is it common for someone to enter a plea agreement and not know what their outcome is going to be? And I want to tell you, yes, it's absolutely common. And there's an article I wrote called Sentencing by Ambush. And I texted it to you, Jessica, if you could include it in the panel. I'll explain how that happens. People enter plea agreements thinking that they've received some form of negotiated benefit, and they find out at their sentencing hearing, they didn't receive any benefit at all. And that happens every single day in our system. This data would be a cure to that kind of ambush sentencing.
And Judge Blunt, it sounds like you have something to add.
Catherine, I don't know if you remember me from my State House days, but I always have something to add.
And of course I do.
The information, in addition to the information that could help us address racial disparities that Justice Donnelly was talking about, I would appreciate really any information that will help make a better Ohio. And when I say that, I will go back to what I was telling you about the resources for judges in big counties are way more than the resources for judges in rural counties. And when we have this type of information, well, even in Columbus, though, there's only so many mental health beds. There's only so many substance abuse beds. And if you are suffering from mental health and substance abuse, there's almost nowhere, even in Columbus. So we need to be able to have the information to say, for example, Black women between 24 and 28 are oftentimes not ingesting their own drugs. They're buying the drugs for someone else. I'm just pulling that out off the top of my head. So that tells us that they don't need treatment. The treatment beds can be saved for someone else. We have to get the data so that we can figure out how to make the Ohio that we want to make as far as what happens to people who have either admitted or been found guilty of committing a crime. So I would like the information to help with voters, with voting, and also with just making a better Ohio and giving people treatment that they need, as well as avoiding the fact that if you're on one side of the street that's County A and you're Black, and you're on the other side of the street that's County B and you're Black, on one side of the street you get probation, and on the other side of the street you get prison.
Gary, anything you want to add to this?
I'll just add quickly, I'll just reiterate it. If indeed the plan is that we're only drilling down to counties of a similar size, and I had mentioned the 3 above 1 million, I don't know how the rest of it would break down, but you would be talking about, I imagine in those other categories, you'd be talking about a lot more than 3 counties, so let's say the next one is, I don't know, 500,000 to 1 million. That's the next category. There'll be more than 3 counties there. And so when we talk about that accountability for judges, for voters, when we talk about one court being able to compare with another court what's going on, if what I'm hearing is correct about this, counties of a similar size thing, at least the public is never going to learn that. I don't know if that will be information sort of hidden behind the curtain that judges will have access to, but all of these wonderful things we're talking about that can happen and should happen, absolutely, with the sentencing database. Are those really going to come to fruition the way that it is currently being discussed?
And Sara, do you want to add anything?
I think that's a whole separate seminar. That would be the best answer.
All right, and to put you on the spot even further, Sara, there was something in the chat that struck me as really interesting, which was the question of, should the Ohio Criminal Sentencing Commission be expanded to include stakeholders, and by that meaning people who have faced incarceration, probation, etc. And I want to that.
We're open to that. As far as statutorily appointed members, that's not, we don't have that in our current makeup. And, in the past, when we've tried to be inclusive of folks who have been criminal justice involved, it's difficult for them to attend most of our work and meetings because we're a daytime operation. So we're more or less a state agency, and oftentimes those folks don't have the ability to leave their job to attend our meetings. So it's been somewhat of a disconnect, but we're certainly open and would be happy to have participation. And I correspond with folks who write me or send emails or call on a regular basis. So we're open to having that participation if folks are willing.
All right, so Justice Donnelly, I have a question here. What is your vision for the next steps in sentencing fairness beyond the database? And what can we do to see that we move beyond just studying the problem?
Well, I mean, data is going to, it's important it's going to inform judges, prosecutors, and stakeholders in the justice system, but it's also going to inform policymakers on what works and what doesn't. Just because in the past, when we had an active parole board that didn't really make decisions that were transparent, they did things off the record. A lot of their decisions were arbitrary and it was suspicious. It doesn't mean that the design wasn't correct in the first place. Doesn't it make sense for the legislature to consider, should we have a parole board and have transparent hearings on the record with people that use objective criteria to make decisions on who needs to be there and who doesn't need to be there. So those are the kind of policy changes. Bail reform, data is going to be a great informing source to deal with how many people are unnecessarily kept in pretrial detention. In Cuyahoga County, when COVID hit and people were worried about COVID spreading through the county jail, there was a concerted effort by all the judges there to review their bonds. And within a 2-week period, it went from 2,200 inmates down to 900. And it was just simply doing a closer look at, hey, is this bond really appropriate for this person? And the judges, after they did that, it came to the conclusion that it didn't. So why don't we make it a policy incentive or a rule that anyone that needs to have a bond hearing take place so you can have it reviewed could do so, and we'll incentivize that. So these are just, data is the key to reforming the system from the start of it, from the charging process to the plea bargaining, to the sentencing, to the post-conviction realm. I can't stress that it's transparency, letting the public know that how the system is working, and if we're acting properly. That's all it is. And it's the most important ingredient in making sure that the system is working correctly.
Judge Blunt, do you have things you'd like to add about kind of what are next steps? What are reforms you'd like to see beyond the database?
Beyond the database, I would like, I don't know if any of you have ever seen my Facebook page, but things that I would like to see beyond the database is really education. We can have this information, but if no one knows how to use it, it doesn't really matter. And like, for examples, with certificates for qualified employment for felons trying to get a job, it was passed, but no one ever really talked to like chambers of commerce about it. So it's out there, but it's not used as often as it should be. And I would like to avoid that with this database. So let's get it up and running, and then let's tell people how to use it.
Gary, anything you'd like to add about the next steps or other things?
Yeah, one thing that hasn't been brought up today is this database won't and is not designed to cover misdemeanor offenses or the juvenile court system, which is a different court system than the adult court system. I understand that. I don't like it. I mean, it's the ACLU of Ohio's DNA to push it for as much as possible all the time in this realm. But this is a pretty big undertaking as it is. We understand, but we certainly would like to see this eventually go to misdemeanor and juvenile offenses, and not wait literally a generation for that to happen, because that's at least how long we've been waiting for this database. And if we have to wait another 25 years for that expansion, then we will finally, the ACLU of Ohio will be, speaking more about our concerns about this. So, as always with people, contact us at acluohio.org. But, we'll be asking the public to take action to make this the best database, the most informative database with as much information as possible for when this all, finally widespread gets off the ground.
Can I add something? Gary, I agree with you completely, particularly as it involves the juvenile system. I am of the opinion that the juvenile laws that we have on the books were really written when the worst thing that juveniles did were like spray paint on the side of the school. Their system is not necessarily equipped to deal with the modern juvenile. And so I think that if we had information in order to reform some things in that system, it would be great.
So, Chief Justice Maureen O'Connor is retiring, and this has been something that she has really nurtured. And just like Gary was saying, 25 years in the making here. What are the next steps, and what are the kinds of things that all of us on this panel can do to make sure that the database is a strong database that has, is open to the public and has the different components that it needs to have? And I'll throw that out to any of you.
I would just say, let your voices be heard. Everyone who has been convinced by this, take these articles where we're advocating. You have social media accounts, get them on there saying Ohio must go into this direction. Contact your state representatives. Tell them that you fully support this. When the judges come up for election, ask them whether they support this. Okay, this should be a litmus test. This should be a litmus test for anyone who's running for judge, from a muni court position all the way up to the Chief Justice position. Because if there is a counter argument to this, I have not heard it yet. So ask your judicial candidates when they come before you, do you support the database? And if they say no, let them tell you why.
Well, I just wanted to thank you all very much for participating on this panel. I do know that I did not cover all the many different questions. And I appreciated seeing them in the chat. I tried to get it to as many as I could. But I just wanted to thank you all. And with that, I'm going to hand it off to Camille, our moderator.
All right. Mia, could you throw up the slides? I think we have some additional action items and resources for folks. So as we mentioned, we want to make sure that folks know about this database and that our lawmakers understand that we support it. And so we've created an action alert letting folks know. You can email your state reps and let them know they should support funding for the sentencing database. And so we'll send that out as well in some follow-up information. So you can make sure you can get those in and you can share that with your friends. Next slide. And then we have some additional resources. Many things were populated in the chat. We've captured lots of them here. But these are some of the core documents that can help you understand and share all the information that we discussed. And then last but not least, we've got, as I said, this is a 3-part series. So we've got another webinar coming up December 1st on judicial recusal, basically rules for when judges should step aside when there could be an appearance of conflict of interest. And then we also have a third presentation on December 9th. It's going to cover the intersection of race, law, and democracy, all the things that we can do to eliminate racism and implicit bias, and look at how we can diversify our bench so that they really represent the communities that they're serving. So those are things coming up in the works. We'll have all the information for how to join. We appreciate everyone's attendance and engagement and conversation. This has been wonderful. Please feel free to follow up with us if you have questions, and we will send out links to the slides and a recording for folks who may have missed this presentation. So thank you to all of our guests and to our attendees.
Thank you, everyone. Have a good evening.
Thank you again, everybody.